would be GERTZ versus WELCH, the case started in 1973 and the decision came in 1974. The background behind this was that a magazine company that Robert Welch was working for was sued for attacking Keynote and providing false facts about Elmer GERTZ. Now, this case would be one of the will establish gaining monetary rewards for private parties who can actually prove a defamation against said organization or parties. The two parties that were represented in this case were Elmer GERTZ and Robert Welch. Elmer GERTZ, the petitioner, was a lawyer who was representing a family whose son was shot by police. Now, GERTZ believed that the comments that were made by Welch about being a communist and a Leninist was attacking his character and decided to sue for defamation. Robert Welch, a reporter at American Opinion, wrote national stories of how communism was beginning to take over the United States, especially those who were working on the police force. He, as in Welch, reported that GERTZ had a lengthy criminal record as well as being a communist sympathizer without actually verifying it with GERTZ. So, how was this truth found out? Well, it turned out that American Opinion was, simply an opinion. The magazine in itself was just a publication that opened up public interest. Something for, people like you and I to talk about in terms of, conspiracy theories, something that will intrigue the American people. That's why we have publications like the National Enquirer now, where even though some of their stories have fact to them, it still creates a form of interest. And even though Elmer GERTZ was a successful lawyer, many people who were on the case for libel didn't know who he was because he kept a low profile. And because he kept a low profile, the Supreme Court ruled 5-4 that there was really needed to be actual malice shown. And since the jury didn't know who he was, then they couldn't actually prove actual malice against GERTZ. So Welch was in the clear. However, there was much to be needed, saying that he needed some form of actual proof to show that there was actual malintention, which there were none. In the state of Virginia, there are 3 elements that can create a defamation claim. The first element is publication, second one, statement, and third, injury. Now, to be called a defamation, the statements must be false and harm the plaintiff and the community or to those around him or her, meaning family, friends, or anyone within a close connection to the plaintiff. Now, defamation can be called in statements by the following: attributes to the plaintiff, the commission of some criminal offense involving moral turpitude for which the party, if the charge is true, to be indicated and punished, meaning that if the plaintiff were to be involved in something wrong, then that could lead to a defamation case. Meaning if us, the plaintiff, the person who did it, meant it as a criminal offense. If defamation can be in a form of indication in which the plaintiff is infected with a contagious disease. Injury. Attributions to the plaintiff unfitness to perform the duties of an office or employment of profit or lack of integrity in the discharge of the duties such as an officer's employment or hurts the plaintiff in her profession or trade. Injury. So this result of these 5 bullet points came from the ruling of Fleming versus Moore in 1981, which was in the state of Virginia. Public and private limited persons figure. What this is basically determining whether or not you qualify for a person that can or cannot be sued by defamation. Now, there are 5 different figures that can determine whether or not you will qualify or not. Basically, in a synopsis of all 5, if you were involved in something where you were personally involved in damaging or changing the outcome of an event or events, then this could ruin your chances of seeking that limited person's figure, meaning you'll be more acceptable to being sued for defamation. Actual malice in the state of Virginia is, for all practical purposes, any form of intent that was said to bring danger or any negativity in order to earn compensation. Meaning that if you were to publish something and you actually meant to cause actual intent in hurting someone, either via statement, falsify, injury, or an unprivileged quote, then you can be sued for actual malice. In the Commonwealth of Virginia, there are 2 ways to counteract defamation. One is privilege and one is defense. Now, the ultimate privilege is truth. If you have the truth, then you win against any form of defamation. Also known as substantial truth, which if you can provide anything that's factual, then you will more than likely win your case. Fair opinion and comment privilege. Basically, everyone's entitled to an opinion. Everyone's entitled to their own feelings. And if they are true, and if they are fair and they're just, then that also can serve as an advantage to you. Fair report privilege is basically if you have the facts, if you have stats to show that the report or whatever you're presenting is factual, then this privilege will be given to you in the courts of Virginia. Now, the statute of limitations is that a person has only 1 year to report a defamation suit in the state of Virginia. Now, what I learned from the New York Times versus Sullivan, as well as the GERTZ versus WELCH Inc. cases, is that number 1, you gotta get the facts. Fact checking is everything, and especially if you are in the journalism world, where there's been a lot of instances where many of people who report news don't get the facts or they only see things one-sidedly, it tends to affect a lot of things. So if you get facts from both sides, it'll help create a sense of balance for your reporting. Number 2, well, I think this one could easily tie in for number 1 as well, is tell the truth. Tell them the truth. That's all you basically can do, is just to give fair and honest opinion, but to be actually truthful at the same time. And the third thing that I learned is to look, listen, and observe. So basically, what I have to do personally is, you gotta listen out, you gotta look, and you gotta observe, because what some people may say about a certain issue may not be agreeable with others. But if you listen, look, and observe with people from both sides of the spectrum, especially when it comes to politics, then you can develop your own truth from what you've heard and listened. And so, judging by these two cases, the actual malice and truth are two things that are strongly debated upon. People, and myself included, have to pay attention to the facts in order to gain the truth. Thank you for listening to this. It may not have been as plain as I wanted to, but it was fun learning about these two cases, and I hope I can do it again soon. Thank you.